back in session. We'll resume session this morning with a discussion on 415.
No, 412.
I mean, not 415, 412. I get that right?
Yes, 412.
412.
So-
Madam Speaker, you are recognized on 412.
Thank you very much for setting this aside until I was able to speak with the chairperson on public safety and what actually, if you look at the bill, yes, the original title was the Cape Volunteers Patrolling School Campuses on our public school system during non-school hours. The language for the bill, which is in section 1, is exactly the language in the original bill. What then the committee had decided to do in the markup was that they wanted to expand on the duties of the Cape volunteers to, rather than just very specific to our public school system, but to expand it even beyond that to provide other types of security to our community. And this security could be on things such as crowd control, traffic motion, assisting as well in any type of let's say island-wide function, like what's going to happen this summer for the celebration of liberation, that they can provide some security as well. Because the duties now has been expanded, the amendment that was included was authorizing the chief of police to recruit additional volunteers, and then the funding that they have based on the citations is to use the funding to then provide training and support for these volunteers. And because of the expansion now, other than just giving citations for littering and citations for illegal parking in the individuals for disability parking stalls, that we're now dealing with a very different facet of safety, and that is crowd control, and of course patrolling the campuses of our schools. That there may be confrontation, there may be situations where these volunteers who are not retired reserve police officers who have not had the training. So it's critical then that these individuals, these volunteers, the Cape volunteers, actually receive the training to be able to handle the additional duties and responsibilities that would be given them through Bill 412. So with that, I ask our colleagues, and I hope I've explained it a little bit more now compared to what we had experienced yesterday. So thank you very much, Mr. Speaker.
Thank you, Madam Speaker. Did anybody else wish to speak on the bill? Chairman Palacios, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, the original draft of the bill actually specifically cited only patrolling school campuses of the Guam public school system. If this were to pass as it is, then it would be limited to function within the campus. And what the committee did in a markup is to strike that out and just amend the duties and functions of CAPE to include providing security and traffic control. And that way it is the function and the duties that's actually amended to authorize them to be involved there. That way they can provide security in the school campuses. They can provide security during the Liberation Day, during the march, Koku race, and there's also the Micronesian Fair. That's why when I amend the title, it makes it more inclusive, so that then you have a wider area of possibilities to utilize this individual for the same training and the same talent and the same authority that they would be doing within the school campus. And that's the only difference, Mr. Speaker, is to broaden the area of where they can function. But it does not enhance any more the authority that's intended by the original bill, which is to provide security and then traffic direction and crowd control. And of course, GPD is going to administer the program, And the funding for payment of, I guess, stipend, if that's the case, is to use the available funds in the police services funds, which of course they collect through the boat registration, firearms ID, and now 50% from the disabled parking citations. And that is actually why the amendment, Mr. Speaker, to make it more inclusive. And that way, then for the training that we put into these individuals to perform crowd control and security, they'll have more opportunities to be involved and contribute to the services of the people of Guam. And of course, the Guam Police Department, Chief of Police, and the Cape volunteers themselves, especially them, they're very excited, looking forward to this. When we add the current duties, we only add littering authority, enforcement of littering. Originally, it was just enforcement of the disabled parking. But currently, it includes littering. This bill, in its substitute version, Mr. Speaker, will include security anywhere that the government of Guam sees utilize them. Thank you, Mr. Speaker.
Thank you very much, Senator Palacios. Any other senators wish to be heard on Bill 412? Any senators wish to be heard on Bill 412? If not, then I'll invite the sponsor.
Thank you again, Mr. Speaker. What I like to do, because I know that this was a bill that had been proffered by yourself and Senator Munya Barnes, because it's a big thing annually, this coat race, and then we have the Micronesian Fair. These all occur annually, and the Liberation Parade. So what I like to do on page 2, then on line 8, is to add the amendment then that they are to assist with traffic and crowd control, such as, but not limited to, the coat race, Micronesian Fair, Liberation, and Liberation Parade. So that would be my amendment.
On the Wanpat amendment. Any other senator wish to be heard on the amendment? Any objection on the amendment? Any objection on the amendment?
So the motion then is to send it down to the voting file. Thank you. Oh, wait 1 second. I'm sorry. Senator Palacios wants to. Yes. Oh, 1 minute recess.
One minute recess.
Mr. Speaker, in conferring with the Chair of Public Safety, since we were talking about safety, security, traffic control, and all that, we would like to add on page 2, line 8, to right after traffic direction, comma, security, and crowd control. And then on line 11, the same thing, traffic direction, security, and crowd control. So to add the word security.
On these two amendments by the Speaker, any objection?
Thank you very much.
On the motion to send the bill down to the voting file, any objection? Senator Rodriguez, you're recognized on Bill 407.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to request if I can be given a little more time on Bill 407 and move down to my other bill, Bill 408, if possible.
All right. All right, then on Bill 408. You're recognized on Bill 408.
Thank you, Mr. Speaker. Mr. Speaker, I move to place Bill 408 on the second reading file and be allowed to discuss it briefly.
On the motion to accept substituted Bill 408, there being no objection, so ordered. On the motion to place it in third reading file with discussion, no objection, so ordered. Go ahead.
Thank you, Mr. Speaker. Mr. Speaker, Bill 408 is an act to establish the Office of Vital Statistics Revolving Fund. The Office of Vital Statistics under the Department of Public Health and Social Services is responsible for operating the vital statistics process for Guam. The office records and issues birth certificates, marriage certificates, and death certificates. These documents are important in that they are required for all kinds of purposes. The process of vital statistics registration is a basic need of Guam citizens and former citizens of Guam. The critical and immediate nature of the services provided by this program requires that certain staffing levels and service readiness be maintained. Inadequate allocations from the general fund have hampered the Office of Vital Statistics' ability to provide reliable, consistent service for Guam citizens. To alleviate this problem, it is necessary that revenues generated from vital records issuance be deposited into a vital statistics revolving fund that is separate from all other government and departmental accounts or special funds. Depositing these revenues into a bank account solely established for the Office of Vital Statistics operational and maintenance encumbrances is critical for daily services and uninterrupted automation capabilities. If granted, Mr. Speaker, this essential function of government will better be able to meet rigid standards as dictated by local laws and federal guidelines. The funds generated from fees for the services provided are deposited into the general fund of the government of Guam, and this critical program is unable to realize any benefits from the money collected for their services to fund the cost of operations. That's why when we visit public health in Manila, you notice that the line at that counter is always very long. And you talk to people there, they wait 1, 2, 3, 4, even 5 hours to get processed. Mr. Speaker, the government of Guam will continue to be responsible for the basic infrastructural needs of society. Automation of these records will enhance capacity to thwart sophisticated identity theft efforts. The need for documents that are tamper-proof require higher cost security paper and skill in staffing to assure vital records are secure and accurate. Also, the only source for one to require certified copies of a vital record is through the Office of Vital Statistics. This necessitates a sophisticated, high-speed, secure computer system linking the hospitals and the Office of Vital Statistics. Rapid turnaround time from event occurrence to availability to issue or generate data in order to meet personal, statutory, and contractual requirement is essential. As a byproduct of the vital statistics registration process, health data are captured when vital events are prepared. Vital records are the source of the most fundamental public health information. Statistics generated from these data have documented health issues and henceforth incorporated in applications for federal funding for Guam. Information on birth and death, such as prenatal care data, maternal risk factors data, infant mortality data, causes of death, life expectancy, disease incidence, and years of potential life loss are core statistics of public health surveillance and management. Vital statistics are regarded as the gold standard for health information available to public health officials at the local and national levels. This information is often utilized in legislation and public initiatives for potential enactment of public laws. It is critically important to programs throughout not only the island but the nation. Other health-related programs rely upon timely, accurate, vital records to carry out their responsibilities. For example, the maternal and child health, neonatal screening, immunization registry, and disease surveillance. The Office of Vital Statistics also fulfills contractual requirements with many local and federal programs such as the National Center for Health Statistics, the Social Security Administration, Child Support Enforcement, Medicaid, Medically Indigent Program, among others. Partnerships with these agencies result in efficiencies in government that could potentially save millions of taxpayer dollars. The people running this critical program are under a lot of strain because it is underfunded and understaffed. Members of the staff who have retired from the office have not been replaced over the years. It's staffed by only the territory registrar and 2 vital statistics clerks who serve the needs of the entire population of Guam. Making matters worse, the office is burdened with using antiquated computer system to manage their files. The staff has to hand out records to retrieve data, causing them to become frustrated and overworked. The process for the public to obtain the certificates they are responsible to produce is unnecessarily long. It is the intention of this legislation to ensure that the fees generated by the Office of Vital Statistics will remain with this vital program. The funds shall be utilized by the office to support and enhance its programs, to include a fully automated computer system and additional staff. I firmly believe this can be accomplished by creating an Office of Vital Statistics revolving fund to facilitate a more efficient service to accommodate more clients on a timely basis. And as we see, Mr. Speaker, what's happening with other departments and other sections of departments is that these branches collect a fee for the services they produce, and that fee is deposited into the black hole, which we call the general fund. And most of the time, the cost of providing that service doesn't reach that section or that branch because it's used in other areas. And so really, if we talk about wanting to make our government more efficient, to operate efficiently, to provide the service to our people, then we really ought to start looking at initiatives such as this that would ensure that the fees collected for the service that provided are kept there and used for the cost to provide that service. So I ask my colleagues to please join me and please support this bill. Thank you very much, Mr. Speaker.
Thank you very much, Senator Rodriguez. Any other senator wish to be heard on Bill 408? Any other senator wish to be heard on Bill 408? If not, then I'll invite the sponsor to move. Okay. Just on the motion to place 408 in the voting file, any objection? Do you want to do 407 or do you want me to take? Okay. Are you ready? All right. Then the next bill we'll hear is Bill 411. Senator Munya Barnes, you're recognized.
Sidus Masi, Mr. Speaker, Manana Sidus. I'd like to move Bill number 411-31CR as amended by the Committee on Appropriations, Taxation, Banking, Insurance, Retirement, and Land to the third reading, and I'd like to speak on it, please.
On that motion, seeing or hearing no objection, so ordered.
Mr. Speaker, Bill 411-31CR is an act to authorize the Magalan, Guam to transfer abandoned properties located within the tract number 113, also known as the Sagan Linadzan subdivision, from the Department of Land Management to the Guam Housing Corporation for the purpose of affordable housing. And if I go section by section, Mr. Speaker, Public Laws 21-60, 2172, and 21-146 gave the Department of Land Management the ability to transfer certain government of Guam properties to qualified individuals for residential use. These individuals signed a contract that if they pay the government $2,500 amortized for a 10-year period, they would receive a deed to the property in fee simple. Unfortunately, Mr. Speaker, some of these individuals were unable to meet their obligations, and the property was returned to the government of Guam. With the land returned to the government, and in keeping with the mission of the Guam Housing Corporation, the land would best be used if it's turned over to GHC to be rehabilitated and turned into affordable housing. Section 2 Mr. Speaker, gives the approved transfer, gives the governor of Guam the authority to transfer the land from the Department of Land Management to GHC. It talks about the different lot numbers within the Linazan subdivision, and the Guam Housing Corporation on Section 3 states that it must remain consistent with their mandates as outlined in 4GCA, which is included in Chapter 12. And of course, Section 4 of the bill talks about the enactment. Mr. Speaker, I just want to say in June of last year, I made a statement that I believed it was our responsibility, the responsibility of my committee as oversight of housing, to turn abandoned homes into affordable homes. And whenever we find them, with the assistance of you, Mr. Speaker, and we've transferred DOE staff housing to GURA in the past to be rehabilitated and used for affordable housing. And in that same journey, Mr. Speaker, we look at these lots in order to provide for affordable housing to our community residents. A few months later in November, during GURA's open enrollment, you and I know that there were 3,300 families who stood in line for their chance at receiving affordable housing assistance. And that staggering number was a testament to the overall demand for affordable housing solutions. And when presented with the opportunity to be able to utilize other abandoned government of Guam property for affordable housing, I felt yet another great opportunity to create more affordable homes, and it fell in line with what continues to be the forefront of my commitment to our island, Mr. Speaker. Bill 411-31 aims to continue the program we began last year by transferring abandoned lots from the Department of Land Management to Guam Housing Corporation. And while working closely with those agencies within our government, we were able to identify funding resources that will make the structures on those lots livable again. And if the lines at the open enrollment in November taught me anything, it was that many of our people are without a home and are without an affordable home. This commitment and this legislative body were able to make progress in our efforts to meet the demand of affordable housing without further burdening this government. The bill addresses the demand in a manner consistent with fiscal responsibility of this body and, of course, this our government. And I'm going to ask that my colleagues help support me in this endeavor. I want to say, Mr. Speaker, I know that with the administration's efforts in moving and forward in as far as looking for a solution for affordable housing, for me it's a realization to not just our working class families, but those within the indigent community who want to provide for a better life for our people and for their children. And when you provide a better home, if you provide something that they could call theirs, or to work to putting a shelter over our children, that means the domino effect is greater, and that when you provide a good home, you provide for a stable family unit, which provides for many a sound education, sound relationship, and just being a better citizen to the community. So, Mr. Speaker, I just want to say, Ondunkalina Sizos Masi, for giving me the opportunity to speak on this measure, and I ask that my colleague support this efforts. I do want to add, Mr. Speaker, that in this effort, my colleagues would wonder why that all these lots are put into this one bill instead of having 10 different lots, Mr. Speaker, but because it's the same subject matter in the same area, just the different lots, notwithstanding the provisions, I guess it was allowed for us to hear it as a one subject matter as it relates to Sagan Linadzan. So, Madam Speaker, again, I know there's a switch there. Thank you for giving me the opportunity to speak, and I pray that, and I'm very hopeful that my colleagues would support my efforts in providing more affordable housing solutions so that our families here in Guam can truly realize that Guamanian dream. Sana Masi.
You're very welcome, Senator. On the motions, anyone would like to speak on Bill 411? There being none, so no objections, and to send 411 to the voting file. So ordered. Vice Speaker on Bill 415.
Madam Speaker, I'd like to ask that the bill be sent back to committee.
On that motion,
back
without
to me.
any objection, so ordered. Senator Palacios on amended Bill 429.
Thank you, Madam Speaker. Madam Speaker, I like to move Bill 429 to the third reading file for purpose of discussion and then, of course, eventually voting. And if I may give an overview.
Please proceed.
Madam Speaker, Bill 429-31 proposes to authorize for the utilization of the civilian volunteer police reserve officers to fill in positions temporarily left vacant due to military deployment of regular officers. Currently, only GPD retirees are permitted to fill in. Unfortunately, the policy is not appealing, I think, any of the retirees. But that is the current policy with respect to fill in the temporary vacant position. Bill 429 proposes to include the Civilian Volunteer Reserve Program. And when the reserve officer fill in, he's actually filling in not as a volunteer, but as a temporary GPD officer and to be paid in the same manner as police retiree would have been paid. And I understand it's just the basic salary of a Step 1, PO1, and maybe Social Security, and of course covered by women's compensation. And there is a criteria established, Madam Speaker, for a civilian volunteer officer to be accepted into the program. One must be an active member. And I say this because there are officers right now who are still on the roll call, on the roster, but they're not active. And I venture to guess that when Bill 429 passes, they probably would come back to life and maybe start to offer and participate. So there is an intention for including that a member has to be currently active, currently performing at least several hours a month, but on the roster, I mean. And another criteria is that one must perform 2,080 hours in voluntary service. So you have a record. 2,080 hours is the equivalent of 40 hours a week, 52 weeks in a year. And maybe an officer can accumulate 2,080 hours during a 3-year period, a 4-year period on a voluntary basis. I know, Madam Speaker, that there are people who already qualify that and who are still active, so they are available for immediate utilization. Now, the background of this is, Madam Speaker, just the normal shortages within the Guam Police Department through annual leave, sick leave, vacancies that are not funded or not to be filled. This is compounded by temporary officers who are deployed, sometimes up to 6 months of some of these officers, sometimes 12 months, sometimes 18 months. There's an incident, there's one police lieutenant who was on military deployment and on island for more than 5 years. GPD is stuck with not able to fill that vacancy. And this lieutenant, while on deployment leave, supposedly, I don't know whether it's voluntary, I would think it's voluntary because it's already 5 years, is promoted to police captain. And so these are the issues, you know. And every law enforcement agency is actually faced with the challenge, not just to fill vacancies, because I think that is dictated by ADILO, but at least to be able to utilize some of these available people to help them. And that is really why I introduced this bill. And GPD, of course, and the Volunteer Reserve Program support this bill. And on page 3, Madam Speaker, actually page 2 and page 3, is that the Guam Police Department would be authorized to use these individuals if a critical need arises because of military activation of police officers or absence to a long-term disability status which had been certified by a medical doctor. And there are, I think, one or two that is, I think, on compensation disability or temporary disability for 3-4 years. These are the hardships that burdens the Guam Police Department. With Bill 429, it would alleviate some of that, but not just that. Then it would increase and enhance the services to the people of Guam of protection and patrolling. These officers are capable, but they have to be authorized to be utilized by the Guam Police Department. And with that, Madam Speaker, of course, I ask my colleagues to, for their support. Again, these officers are well trained, but they're just not now authorized to fill in and be compensated, not as an officer, a volunteer, but as a regular officers, Madam Speaker. Thank you.
On the motion, Senator Tom Atta, you're recognized.
Thank you, Madam Speaker. I rise in support of the bill. And I can see where a situation like this certainly be very helpful in that we do have to face the reality that we do have officers in the Guam Police Department that do get placed on active duty and are either serving that active duty time here on island or are deployed off island. And so, of course, when they leave, that leaves a vacancy here, which presumably, I guess when that individual gets deployed or gets placed on active duty, I'm not certain though whether the salaries and benefits of that individual then ceases at that time until he returns. So, and I presume that it does, so that on the day that that police officer goes on active duty and is now getting paid by the Department of Defense, that then the salaries and benefits from Gov Guam ceases. But there are of course, we could have a number of police officers that will be deployed, leaving many vacancies. And by allowing for these volunteer police officers to be brought on after having met certain criteria, to be brought in to fill these vacancies, the funding is already there to be able to pay them for that time that they are serving. And I can see where a volunteer police officer who's brought in to backfill could really stay on in the department for as long as there's a vacancy to backfill. The concern that I have, though, is that, in that kind of situation, this volunteer police officer who has met the criteria to be able to come in and backfill could be on duty for a number of years, backfilling vacancies as they arise and for which he or she may be qualified to fill. So in that regard, I don't understand why we can't provide that individual with the benefits that would otherwise be given to any other had he come on as a regular police officer. So in other words, he comes in and he backfills, and if he meets all the qualifications to be promoted to a police officer 2, and he has those qualifications, I don't understand why he will not be able to compete, understanding full well that of course the higher up you go in the organization, then the less there are less positions that may be available for that individual to be able to backfill. For example, there may be 10 police officer 1 positions and maybe just 5 police officer 2. And so, the individual is going to have to weigh that out as to whether he wants the short-term gains or the long-term gains to be able to stay for as long as he can until, in fact, a full-time position comes open. So I do have concerns, for example, on page 3, on line 7, it says that the civilian volunteer police reserve officer may only serve as the equivalent of police officer 1 and be compensated hourly only as a police officer 1, step 1, and shall not receive sick leave, annual leave, or be eligible to the Gov Guam health insurance program. Well, I don't understand why we have to limit that, since the budget is already there to pay for that. And then he goes on to read, and shall not be eligible for a stipend as a reserve officer for the duration. That part, I guess, means, you're not going to double dip, if I understand correctly. You're going to get the pay of a police officer 1 who puts in 8 hours a day, and you're not going to get on top of that the stipend for the police reserve. So I think that part I'm fine with, but I would like to make the amendment well, then maybe the author can clarify as to why we cannot change that, so that he is in fact eligible for sick leave, and he is in fact eligible for annual leave. So maybe if the author can clarify that.
Senator Palacios, a point of clarification.
Thank you, Madam Speaker. Yes, of course, but this is the same language that currently applies to retirees. And if we were to entitle them to annual leave and sick leave, then it would include also the retirees. And I remember about 3 years ago when we started doing this, is that was one of the, I guess, the reservation of most members at that time, that a retiree coming in will still continue to receive, of course, the retirement. But then when they come in on a temporary, it will be just basic pay and workers' compensation, but no other additional benefit. That's actually why I adopted the same language, so that it parallels with that for the reserve officer, for the retirees. But if we're going to add annual leave and sick leave to the civilian volunteer reserve officers, then we have to understand it would also probably apply to the police officers. There are other provisions to, for example, customs and quarantine and fire, that they can actually employ retirees, but it's all the other agencies adopt the same identical language of just the salary at step 1, PO1, and of course workers' compensation and maybe Social Security. That's the reason why, Madam Speaker.
Thank you, Senator. We're going to take a brief recess. legislature is back in session, and Senator Ada, you still have the floor.
Thank you, Madam Speaker. I'd like to make an amendment to Bill 429-31. On page 3, starting at line 7 there, the sentence where it reads, CVPR officers may only serve as equivalent of police officer 1 and be compensated hourly only as a police officer 1, step 1. And then the amendment will read, and shall be eligible to receive sick leave So what it will read is, and shall be eligible to receive sick leave and be eligible for the Government of Guam Health Insurance Program. We will delete on line 9 the words annual leave or, and then on line 11 the words unless otherwise eligible. So then now, reading back, on line 9 it will read Police Officer 1, Step 1, and shall be eligible to receive sick leave and be eligible for the Government of Guam Health Insurance Program and shall not be eligible for a stipend, and so on down to line 13, ending with the word department.
Does everyone understand the amendment? So on the amendment, are there any objections? No objections, and so ordered. Anybody else like to speak on the motion of 429? There being none, Senator Palacios, do you want to close? So on the motion and to send 429 to the voting file without any objections, so ordered. Okay, so you're 407, right? Senator Rodriguez on amended bill 407.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 407, the third reading file.
And you would like to speak on it?
Yes, ma'am, please.
Okay, please proceed.
Thank you. Madam Speaker, Bill 407 is an act to provide for the court-imposed penalty requiring the taking of advanced defensive driving course for the offense of reckless driving. I believe we all find it alarming that Guam's collision rate is twice the national average, with an average of 40 collisions per year for every 1,000 motorists. The national average is approximately 19 collisions per year per 1,000 motorists. Over the past 7 years, there has been an annual average of 18 fatalities caused by motor vehicle crashes on Guam. Defensive driving is a method of driving that minimizes the number of driving risks using more advanced skills than just your basic training. When you employ defensive driving techniques, you become a better, safer, and smarter driver. Losses from traffic crashes have both a social and personal impact. Aside from injuries or the tragic loss of life, collisions slow down or even halt the flow of traffic. My goal is to enforce a proactive approach in reducing the number of incidents by requiring drivers to educate themselves and change their driving behavior for the violation of reckless driving. Defensive driving courses are used worldwide by several branches of the armed forces, police forces, ambulance, and fire departments. Defensive driving classes have been court-approved by at least 28 states to reduce deaths and injuries caused by inexperienced drivers, aggressive drivers, and alcohol, drug, and related motor vehicle crashes. If enacted, Bill 407 will be an advanced course in defensive driving that will be required by a judge for even a first offense, depending on the level of wanton recklessness and other circumstances. A second offense, Madam Speaker, shall require the mandatory taking of both a driver education course and an advanced defensive driving course. Defensive driving courses are also an opportunity for good drivers to learn more about safe driving while lowering their auto insurance rates and making streets safer. The class will utilize lesson plans with a proven record of reducing accidents and will also include operating a vehicle in adverse weather conditions such as heavy rains and dealing with driving around larger vehicles, pedestrians, cyclists, and aggressive drivers. Madam Speaker, I have first of all, I want to also just thank the committee, Senator Palacios' committee, for working very hard in putting this substituted version before us today. There was one section here that I wanted to amend, Madam Speaker, and that's on page 4, line 14. I'd like to add a new item, II, to read, all costs for the taking of a defensive driving course as ordered by the court shall be paid by the person convicted of the offense of reckless driving. And so a lot of times, I haven't passed it out, so I just
But
read it, so
you're
I'll
right.
have it.
Can we please make sure that Sergeant at Arms? Sergeant at Arms, where are you? Please, Tom, can you please take the amendment from Senator Rodriguez that copies?
Let me just read it before. It's all costs for the taking of a defensive driving course as ordered by the court shall be paid by the person convicted of the offense of reckless driving. Thank you. And so during the public hearing, and a lot of times when we mandate, several things, a lot of times, we forget about the costs and how to implement it. And so, I think that the violator in this case would be responsible to pay for his or her driving course. And so this was something that was brought up in the public hearing. And so I wanted to make sure that we include that in this measure. Thank you, Madam Speaker.
So, well, the copies are being made, of course, but in essence, you're saying that it would be at the cost of the person, the violator.
The violator, that's correct.
Okay. So on the amendment, oh, not on the amendment. On the amendment, is everyone okay with the verbal discussion of the amendment rather than getting your own copy? No objections then, so order it. On the motion, Senator Munya Barnes.
Si Diyos Masi, Madam Speaker. Madam Speaker, I can understand the intent of the bill. My only concern is that a person must go through this driving course or retake this driving, defensive driving program and the driver's education course, and it said may or may not have resulted in bodily injury, or property damage shall, upon conviction of filing without contest. So I guess my question is, if a person receives a citation for reckless driving and has more than two offenses, but wants to plead not guilty, I know that there are rules and regs on how that process goes through. Will they still be required to take it?
Senator Rodriguez, we have a question for you. Can you repeat the question again?
The question is, if a person has, this says that, the first question again is, this bill specifically says that they would have to take this defense driving program and driver educational course if they have more than two or more.
For the first offense, Madam Speaker, it would be the court that would need to order.
Because it says accumulated 2 violations. Right?
That's for the second offense. Then it'll be a mandatory. Taking of this course.
So my question, Madam Speaker, then again is, if in order for a person to not go through this program, then they would have to contest and go through the process of the court. Am I saying that right? Because every person is innocent till they're proven guilty. So it must.
On page 2, lines 26 and 27, at the discretion of the judge for the first offense,
Right.
may be required. So it's the judge that will make that determination. And then second or more, it's automatic, it's mandatory.
Yeah, I just want to say, Madam Speaker, for the record, not that I don't support the intent of the bill, but I've seen it where constituents would get citations for reckless driving because this one police officer would have issues with a constituent and cite him for something that was beyond the driver's control. I'm just saying food for thought. Thank you.
You're welcome, Senator. On the motion, I recognize Senator Palacios.
Madam Speaker, I rise in support of Bill 407 as amended, of course, in the committee. And this bill actually is different from a bill that that my committee is working on so-called point systems for requiring retraining or defensive driving course. Because Bill 407 is only, it could be a one-time reckless driving. Madam Speaker, if one reads page 3, line 18, the definition of reckless driving, I mean, it is serious. It is not just a person failed to stop or a person speeding, but where a person drives in wanton disregard, that's almost complete disregard of personal property, and such reckless driving of a vehicle approximately causes a collision in which bodily injury or property damage results. That is the definition. That had to happen in order for a conviction of reckless driving to occur. And that's why reckless driving is a very serious offense. It is more than a moving violation. And that's why this bill, I support this bill completely because it's reasonable and it would strengthen, of course, the road safety policy that we have. How is this different from a bill? I don't have right now off my head the bill that I introduced, which is actually, my bill that I introduced is any 3 moving violation within a 12-month period, that driver, before his license is renewed, must be required, must be checked for driving record by revenue taxation in coordination with the traffic court. That's how it is. A moving violation is speeding, failed to yield right away, failed to stop at a stop sign. A non-moving violation is no driver's license, no registration, defective headlight. So any 3 moving violation within a 12-month period, a defensive driving course will be required. So that is where that bill and Bill 407 is different. Bill, like I said, Bill 407, just one-time conviction, and that will be sufficient. And you don't have to go to court. Conviction is whether you plead guilty or you went ahead and paid the fine and you don't contest it. Anytime that there's a record, and then Bill 407 is actually for the first offense, it's at the discretion of the judge. My understanding, the current policy of the court is that even first conviction of a reckless driving, it's $800 fine, and I think 30 days suspension of a driver's license, with of course a special permit to drive to and from work. Right now, that is the policy, and again, that's exercised by discretion of the judge. Bill 401 Bill 407 continue to allow that. On a second offense, it is now automatic. The second offense within an 18-month period of reckless driving, then that person, in addition to court-imposed penalty, must take a defensive driving course. And I rise in support of this, Madam Speaker, Bill 407. Thank you, Madam Speaker.
You're welcome, Senator Palacios. On the motion, I recognize Senator Sam Abini.
Thank you, Madam Speaker. I also rise in support of Bill 40731. I've been educated much about this field, mainly because of individuals who are experts in this area, but not to mention also that I'm always interested in any form of training for our individuals, for our community. And one of the things that I wanted to point out, and I'd like the author and the previous speaker to the author to yield to this question after I give a little bit of background. What I understand, because I wanted to know this, I wanted to see where Guam was when it came to these types of programs. And then I found out that 40 of our states have these programs. Three of our states have these programs at the county or the court level. 8 have them down at the very lower, court divisional level. And many of these states only accept programs that have, that have demonstrated some studies that show that there's actually been a reduction in accidents or reduction in citation recidivism, which is what we all want. I just came back from a trip, and sure enough, as what my research has revealed to me, that California, for one, including Arizona, but California is the largest state with the largest number of defensive driving schools. And what's interesting to me is that how the various ways how how counties, how states, how towns handle their defensive driving, and it varies. One, for example, is Santa Clara, and I know one of my colleagues is from Santa Clara, or had gone there, lived there. Population of about almost 2 million people, and they have only one single defensive driving school. In another small county that has only 1,075, they have almost nearly 100 online schools. And so this bill, what I understand, helps kind of manage that, because as we know, many programs are arriving on Guam, schools, universities, who sometimes I consider carpetbaggers. They come here, they offer programs, no revenues, it stays on island, and they leave Guam. In the meanwhile, some of their programs are not even Guam-centric. And so I commend the author for including those kind of parameters in this bill to ensure that we protect our constituents. But I do have a question for the previous, for our author, who is also probably familiar with the previous speaker's bill that would be coming up regarding, I believe it's a point system. And I think the concern that I have is that and I know this is not the arena to discuss that particular bill, but I know that this bill deals with the court system, and that particular bill would only focus on licensure renewal. So what Bill 407 is attempting to do, according to what my understanding is, the intent is to give the courts a tool to manage the large number of individuals with not just reckless driving, but with what is the term for it? Not reckless driving. Moving violations. There you go. So majority of what the court systems and our Chief Justice last year had reported that majority of their a big bulk of their court load is moving violations, and reckless driving only constitutes only about 100 some versus thousands of moving violations. So my question to the author is, would he consider, because this bill is specific to the tools that the courts can use and not license renewal, would he consider amending this bill to reflect not only reckless driving but also moving violations, which would significantly assist our court system, because just like what our courts use as far as sending individuals to, let's say, alcohol classes or whatnot, this is something that states use as a tool to help reduce recidivism, to help reduce court, because, by the way, and then I'll give you one story. I have a relative who in Arizona, and also one in California, who just recently got caught for speeding. Immediately, the court did not have to take him into court, take up, the budget of the court. They immediately assigned him to defensive driving school. It's either face-to-face or online. So this is, from what my understanding is, the intent of the bill is to get those individuals, not those that are, as was defined on page 3, the reckless drivers who have wanton disregard of persons or property. Disregard of persons or property. Those are the ones that usually end up in jail, or have a criminal points against them. What we want are those individuals, some of them probably here in our hall, are those who probably need a defensive driving kind of program to help remind us how to be safer on the roads, how to be better drivers, how to be a lot more conscious. And these are programs these are courses or educational curriculum or whatever. That's not what a typical student would get at the driver's ed. Driver's ed is for people without driver's license. Defensive driving are for those who are like us, who have driver's license, and we need to be reminded and probably refreshed about what kind of rules are we should be abiding by so that we can keep ourselves safe and those others on the road. So again, I'm asking the author if he would yield to the question if he would be amenable to an amendment to include not just reckless driving but moving violations.
On the amendment is to include moving violations aside from reckless driving. On the amendment, Senator Palacios.
Madam Speaker, I object to that amendment. Again, to include any moving violation is actually, Madam Speaker, would pose an almost unreasonable penalty to a driver that just failed to stop with no incident. The person happened to be caught by a police officer at midnight. This guy take a chance and run over a red light. That is a moving violation. Now, again, Bill 420, and it has nothing to do with that bill, but that Bill 420 eventually would have the support of the insurance industries because it's going to define the point systems. And you will not drive. Your license will not be renewed unless if you have a 3 moving violation within a 12-month period, you have to take the defensive driving course. The burden will be placed on you to better yourself. Now, this current bill, Madam Speaker, Bill 407, is for that intense, very serious disregard for personal property while driving. And this is not just speeding, but speeding in the village, speeding in a crowded street where the potential for... So we cannot just treat the same way a reckless driving to include just any moving violation. Because it would actually pose a burden. And even though, Madam Speaker, the statistics for reckless driving is not that many, thank God it's not that many, because it is that serious. But it is common sight nowadays. You see people driving 50 miles on a 35-mile zone. That is a moving violation. You do a California stop where you don't stop completely on a red. That is a moving violation. You almost cause an accident because you failed to yield right away. That is a moving violation. And if we were to require defensive driving for any of that at the expense of that officer, it's overkill for the ordinary moving violation. And that's why I rise in opposition. Thank you, Madam Speaker.
On the amendment, any other speakers? Senator Mabini, would you like to close?
I understand the concern of the previous speaker, and I think I was at one point where many of us are at right now as far as the understanding of how these programs work. The court systems in the States, as well as the court system here in Guam, have expressed interest in this because of the thousands of individuals with moving violations. These are exactly the same people that are supposed to benefit from this. The court systems in the states that have defensive driving in their states are not designed for reckless drivers. They are designed for the moving violators, the ones who need to be reminded why you should slow down, the ones who should be reminded why not to be on our cell phones, the ones who are supposed to be reminded why we should be looking in our rearview mirrors, the ones who should be reminded as to why taking allergy medicines can cause drowsiness and so forth and so on. We have private companies right now who are taking these courses, putting their whole cadre from the janitor to their executives, taking defensive driving for the purpose of making sure that they protect themselves and the community. So I'm asking the author, and again, I would like to again put forth the amendment to include this because it matches the intent of the bill. The 6,400 crashes that we had last year were not made by the reckless drivers. They were made by the moving violators, the ones who were not paying attention, who would benefit from the defensive driving courses. We have schools on island who are waiting. I understand that from the author that there are schools, in fact from the states, who are wanting to come to Guam to offer these very same programs that they offer their states. My nephew, who just moved from Guam, from Derrido to California, Vallejo, California, he made the mistake of driving fast or maybe not making a signal. Immediately he went into defensive driving. And believe you me, he doesn't want to go back, have to go back. He went to class, he learned his lesson, he paid his $300 fine for not making a signal somewhere in the freeway. He was not a reckless driver, he was a moving violator. And this is what defensive driving is about. I know that we, are all individual experts in our respective area, and I've taken a lot of time to understand this, whether it is even viable for Guam. And I feel that it is viable for Guam. We've had thousands and thousands and I don't have the exact number in front of me, of how much is taking space at our courts, how much our judges are spending so much time on moving violations. They have people who are coming in to regarding alcohol abuse or whatnot. And what do? They send them to these classes. They don't send the ones that immediately are criminals. They send people who would benefit from these programs. So this is equivalent to it. And I'm asking the author and the previous speaker to please consider this, because defensive driving programs, as they are designed in the states, as they are designed and the extent, are for those people like you and I who are not reckless drivers, who make the mistake and need to be re-educated about or retrained, reminded how to be better, effective drivers on our roads, especially with all the distractions that we have today. Thank you, Madam Speaker.
Okay, we're going to take a recess. the legislature is back in session. I understand, Senator Mabini, we're back to your motion, the amendment that you had proffered, and there were several discussions during the break.
Thank you, Madam Speaker. I appreciate the dialogue that I had with my colleagues, and upon discussion, I will go ahead and withdraw my suggested amendment. Thank you.
Hearing no objections, so ordered. So Senator Rodriguez, on the motion then to send, on your motion to send it down, or would you like to close? So the motion to send 407 to the voting file without any objection, so ordered. Vice Speaker on 430.
Thank you very much, Madam Speaker. I'd like to move to accept substituted Bill 430-31 as substituted by the Committee on Youth, Cultural Affairs, Procurement, General Government Operations, and Public Broadcasting.
And would you like to speak on it?
Yes, ma'am.
Okay.
Madam Speaker, the bill as was introduced was not produced by my office. It was introduced by my office at the request of Public Health and Social Services, who brought it to me. I had a public hearing on the bill, and I had probably one of the most educational mornings and enlightening mornings in my 8 years here as a member of the Guam Legislature at that hearing. I had not stopped to think about the value of these cooperative purchasing agreements until this bill was heard by my committee and the discussion ensued. At the public hearing with the original bill, which was prepared, incidentally, by the Attorney General's office for public health, who submitted it to my office and requested to be introduced. At the public hearing, Public Health did its homework, and I commended them for it. They came in with a comparison of why they wanted to do this, and they were able to provide for those of you that attended the hearing, and I provided you with all copies of this, and it's in the committee report, of a breakdown where they did a comparison between 3 contracts that they could possibly get into off-island and the average price to buy that same item here on island. They did this with several items, Madam Speaker. They did it with, I probably should go back and explain. The division at Public Health and Social Services that was concerned about this was the WIC program. And the reason why they had this legislation, and I know there was concern in the community about why this was necessary and saying that it was not necessary, I'd like to read into the record the memo from the Attorney General's office, and this is dated January the 18th, 2012, from the Attorney General's office to the Director of Public Health and Social Services. It starts, and the subject is Master Pricing Agreement and Participating Addendum for Breast Pumps and Accessories with the Western States Contracting Alliance. And the first paragraph reads as follows. A sourcing multi-state agreement has been entered into by the state of Washington and 3 contractors for multi-state term, initially January 18, 2011 through January 17, 2013, with a maximum of 6 additional years through 2013. The purpose of the agreement is to facilitate as needed purchases of manual, electric breast pumps, breast pump kits, and related accessories in keeping with the USDA Food and Nutrition Program for Women, Infants, and Children Program, the WIC program. And it goes on. GSA, on behalf of Public Health and Social Services, has submitted master pricing agreements and participant addendum with 1 Medela Inc. and 2 with Even Flow Company, subject to the terms and conditions of the contract. Both contracts offer destination pricing FOB USA territories at no charge. And this is the part that I would like the community to understand for the reason for this bill. And this is from the Attorney General. I unfortunately am unable to recommend the master pricing agreement and participant addendum subject to the terms and conditions of the contract for approval for the following reasons. 1, Guam procurement laws and regulations do not permit cooperative procurements of this nature. In the 30th Guam Legislature, there was a bill that proposed similar language be added to the Guam procurement law, but to date, no such law has been passed. Cooperative procurement is part of the updates of the ABA Model Procurement Code. 2, DPSS authorizing statute for the WIC program does not have any special provision permitting the cooperative procurement of program materials in this manner, and as such as is permitted, for example, by Guam Memorial Hospital for certain medication procurements. 3, although there are USDA food and nutrition regulations that permit this type of cooperative procurement, they do not mandate the cooperative procurement process be followed. Federal laws and regulations do not therefore preempt Guam's procurement law regulations in regards to this item. 4, this type of cooperative procurement, as per NASPO, the National Association of State Procurement Officers, issue brief attached, a piggyback option. A piggyback option is described as where one or more organizations represent their requirements and include an option for the organization to ride or bridge the award as awarded. Guam law and regulations do not permit this type of procurement. Local Guam vendors do not receive notice of the procurement, and Guam laws and regulations are not adhered. GSA and DPHSS are not permitted to ride on the contract. 5, since there is a signed upfront intent to participate form that permits GSA and DPSS to set forth the requirements, I'll skip that. But anyway, those 4 reasons were the reasons why the Attorney General prepared the original Bill 430. At the hearing, Public Health and Social Services enlightened the committee about what the savings were going to be. They pointed out that from some of these companies, you could get delivered to Guam, shipping included, electric breast pumps for $86. Sold on Guam, they found 2 vendors. I won't name them on the air. One place was selling it for $403. Another vendor was selling it for $489. There was another one that they were a multi-electric breast pump. I'm sorry, I don't understand. I'll just read them. Were for $299 or up to $305, and without shipping was $191. On Guam, these same breast pumps were being sold for $550 at one company, and at another, for some reason, was actually cheaper at $233. For a reconditioned multi-user double breast pump, they could get it for $199 on island, and for some reason, only one vendor was selling this, and it was at $675. For manual breast pumps, they had one for set that you could get delivered on Guam with shipping, $7.95, and without shipping included was $9. Locally, it's being sold for $365, and another place was selling it at $53. Needless to say, Madam Speaker, it's a no-brainer. These kinds of outrageous prices would completely undermine the program. I thought, I had never realized that how much savings this was going to be realized by the program. And at that point, then I started to think about it. All of us have suffered through, those of us that have been here, suffered through all of the crises that Guam Memorial Hospital has gone through over the last several years. And every year we hear that Guam Memorial Hospital is in credit watch because they haven't been paying their vendor bill to some company, and they always refer to it as Perry Point. Well, as was read from the Attorney General's memo, Guam Memorial Hospital has the authority to enter into cooperative purchasing agreements. I don't know how much they actually spend on an annual basis for cooperative agreements, but I do know that when Chairman Rodriguez had a hearing last week with Guam Memorial Hospital, the amount that's still owed to Perry Point at this point this year was $5 million. So we do know that the hospital is buying at least $5 million annually, if not more. I'm not sure exactly how much they buy from this one pharmaceutical. But at that hearing, Ray Vega admitted that there were at least 2 other cooperative purchasing agreements of the hospital for which they realized substantial savings for not only pharmaceuticals, but for their hospital supplies and other things that they need at the hospital. So cooperative purchasing agreements could be a boon, a savings that we could possibly realize throughout the government. At the public hearing, Chief Joey St. Nicholas came from Guam Fire Department, and he expressed his delight that he was able to come to the hearing because just the day before, he was at the Attorney General's office trying to work out his contract to purchase a fire truck or a couple of fire trucks for the department. And while he was talking to the Attorney General, he mentioned to the Attorney General, I know the chief from Anderson and I know the chief from Naval Station, and they've been suggesting that we purchase through a cooperative our fire trucks. And the Attorney General said, I know that would be an excellent idea. We've issued a memo on that issue on January the 18th to Department of Public Health and Social Services, and we've informed them they don't have that authority to do that. The legislature's only given it to GMHA in their, as part of their statute. And so he said, but maybe you should go to the hearing tomorrow morning and inform Chairman Cruz that GFD would like to also have this authority that was being proposed for WIC at Public Health and Social Services. So Joey came down, and resourceful as he is, he brought the chief of both Anderson and Naval Station. And both of them came up because there was a question as to, well, don't we need a special kind of fire truck for Guam? And the new chief from Anderson came up and testified, and he said, well, no. The federal government buys fire trucks in bulk, and they send 5 to Alaska, 5 to Hawaii, and 5 to Guam, and we on Guam don't turn on our heater, and the guys in Alaska don't turn on their air conditioner. But it's the same kind of fire truck. And we get a substantial savings. And this chief came up and testified after a couple of people got up and testified in opposition to it because they kept saying this is in violation of our buy local program, and that it was going to kill into all kinds of businesses on island, and they've been making huge investments on island in their companies, and if we didn't force the issue of making government be stupid consumers and buy things at exorbitant prices, it would kill their industries. And the chief from Anderson got up and he goes, Miss Senator, I've just moved to Guam a couple of months ago to take command of Anderson, and I'm now a taxpayer on this island. I don't understand why there's a pushback of trying to save money. Any money saved will be used elsewhere, wouldn't it? And it was, like being hit on the head. Yes, of course. If we save money in one area, we know that for even as long as you've been in the legislature, the rainy day fund hasn't seen another penny since the day that it was established. There's no savings account in the government. Every time we have extra money, we're using it for someplace else. It goes to pay vendors that haven't been paid for months. It goes to pay tax refunds. It goes to pay for additional personnel. It goes to pay to keep people employed. And these people that are employed are the ones that go out into the community. These are the firemen. If we can save money on fire engines, these are the firemen that, at the salaries that they're getting, would go out and buy the cars at these car dealerships that the people came and testified against this bill. Anyway, Madam Chair, Madam Speaker, that's neither here nor there. And I thought it was an excellent idea that we start to look at this. Since then, there have been letters to the editor about how absurd this bill was, and I was shocked to see that editorial because it came from the chairman of the board of Guam Memorial Hospital Authority, who did not realize that the entity for which he's chairman of the board has a $5 million outstanding on a cooperative purchasing agreement, and he hasn't even looked at his vendor listing of outstanding payables. But that the hospital has several other cooperative agreements. Anyway, because of the scream in the community about the buy local pushback from the chamber and from various companies, I was visited the other day by a member of the governor's staff who asked if I would forbear moving this bill forward and to allow the Guam Procurement Council that we had established by law to discuss this as a cooperative purchasing as a what do you call it? As a proposal for the government saving money and for improvement of the procurement statute, since cooperative purchasing agreements are part of the ABA model procurement law. I told him that I would, except for the fact that I told him that I was going to move 430 forward with just a specific provision for WIC. And the reason for that, Madam Speaker, that I'm doing this is because I was provided with a letter from USDA, and the letter reads as follows. And I know it's long, but I think it's imperative that the community understands why we're doing this and why it's important that the bill, as my committee substituted it, and if you look at my substituted bill, it just says joinder or mutual use contract rather than governmental entities, which everybody was concerned about that it was too broad, and the Procurement Council wants to discuss this. I've now limited it to the Women, Infants, and Children program, which I'm going to ask. It is just specific to the WIC program at Public Health and Social Services. And I know that one of the persons who testified got all ridiculous in his opposition and said, well, we can, the way that the bill is written, that you can also sign contracts with China. And so I've taken out or outside of Guam and put in specifically within the United States, so that nobody's going to claim that we're going to try to do a cooperative purchasing agreement with China. And take out wherever located and make it very specific at the very end of the bill. For purposes of this section, the Women, Infants, and Children program of the Department of Public Health and Social Services is exempt from section 5004 of this chapter. And the reason why I ask my colleagues to please support this substituted version is because I'll read the letter from USDA. We are very concerned to learn of recent issues surrounding Guam's ability to participate in the Western States Contracting Alliance WIC infant formula rebate contract. As you are aware, the Guam WIC program has already been participating in the WSCA contract since the latter's inception in 1992, along with 21 other currently participating WIC state agencies. During this 20-year period, the Guam WIC program has saved millions of dollars in critical WIC food funds through infant formula rebates, enabling thousands of additional low-income Guam participants to participate in WIC benefits. We now understand that the legality of Guam's WIC participation in WSCA has been called into question based on a reading of the Guam's procurement law, and that legislation has been introduced by the Guam Legislature to specifically allow for cooperative procurement among government entities such as currently in place with the WSCA infant formula contract. We would like to take this opportunity to express our urgent support for passage of Bill 43031 in the Guam Legislature. The alternative would be catastrophic for hundreds of low-income mothers and their infants currently served by the WIC program beginning October 1st of this year, when the current rebate contract expires. The reason for this is simple. Of the $7,584,785 available for Guam WIC program participants to purchase WIC foods at local Guam retail vendors during the previous fiscal year, $1,108,006 came from infant formula rebates under WSCA contract. Recent participation shows 1,973 total infants participating in the Guam WIC program each month. The standard 12.4-ounce can of powdered infant formula issued by the WIC program normally costs $13.19 per unit, but with a $12.01 rebate under the current contract, costs the WIC program only $1.17 per unit. To lose the additional source of WIC food funds subsidized by the formula rebates, as illustrated above, would instantly drive up the cost of formula for the WIC infants, likely resulting in over 1,000 children being dropped from the WIC rolls in fiscal year 2013 with a waiting list instituted. Aside from the food funding and participation crises triggered in the above scenario, operating without rebate contract would also place Guam WIC program in violation of Section 24616A, A, and B of the WIC program regulations, which regulate a state agency to continuously operate a cost containment system for infant formula. State agencies out of compliance with this provision may not draw down, obligate any program or grant funds until compliance is achieved. Enforcement of this provision would essentially shut down the Guam WIC program during the period in question. While a logical alternative to Guam participating in WSCA would be procurement of a separate infant formula rebate contract, we do not see this as a realistic alternative at this time. For example, the current WSCA contract procurement process was expedited beginning in October 2011 in order to be in contract prior to October 2012. To begin development of the invitation to bid for formula rebates at this late date, followed by the submission to USDA for review in addition to Guam's internal procurement processes, would almost certainly result in missing the October 1st deadline for a new contract. In addition, it is quite possible that Guam might receive no bids from the national formula companies who normally provide the rebate, or at best, lower rebates that are currently awarded through the cooperative procurement of 21 state agencies. Regardless of the question of possibly hurting Guam businesses, it is clear that WIC-approved infant formula can only be supplied by large island vendors, including the current supplier. To the contrary, the WSCA infant formula contract has greatly benefited local Guam food retailers' sales between WIC Foods and the additional business they bring to the stores. We cannot stress enough just how seriously we view this situation, as we have never had a WIC state agency lose its formula rebate contract since the practice was implemented years ago. We hope this scenario can be avoided by speedy passage of the current bill in the Guam Legislature, and that the Guam WIC program is assured of continued participation in the WSCA contract process. If you have any further questions, call Mr. Crollo, Regional Director, Supplemental Nutrition Program, Western Region. I don't think I could better have stated it, Madam Speaker, so I ask my colleagues to please join me in passing Bill 43031 as it's been substituted by the committee for the specific purpose of the WIC program, limited to the WIC program. But I want it clearly understood, Madam Speaker, that I am not done with this cooperative purchasing agreement. I will see to it that another bill is introduced so that this discussion does not die. And as I have advised the governor, this is a way to be able to save millions and millions and millions of dollars. The hospital has seen it in the past when it's purchased its pharmaceuticals from Perry Point. I mean, to the point where they owe $5 million right now. God knows how much they save by doing that. And they buy hospital supplies from a cooperative agreement and some other supplies from the cooperative agreements. We've got to be able to find savings. I went online, Madam Speaker, and I saw that there are actual state agencies, cooperative agreements for the purchase of books and supplies for school districts, where they've joined together and they've saved in excess of 30% of their supply budget by doing these cooperative agreements. So I'm hoping that we can continue this discussion on cooperative purchasing agreements, but I don't want it on my conscience that we don't meet the deadline for WIC. And so that's why I was willing to sacrifice Bill 430 and make it specific just to WIC, but to continue this discussion on cooperative purchasing agreement in a separate bill that I'll be introducing before the end of this session. So I ask again for my colleagues' support of this bill, and I apologize for the long-windedness of my presentation and the passion for which I did this, but I really am concerned about the safety of the children and supporting their mothers, and as was said in the letter from Mr. Perot, I mean, when these women go to shop at the market, when they go in, they don't just go in to buy baby formula. As they're walking around with all their additional children, they're buying all kinds of things at the store. So there's an additional benefit to the stores for it. But that's for another day. But be assured, I have not laid down the gauntlet on this one. I will continue to fight for cooperative agreement. But I'm willing to just get 430 through on a narrow basis for just WIC to protect the women and children that are involved in this program. Thank you very much, Madam Speaker.
You're welcome. On the motion? So on the motion then to send Bill 430-31 to the voting file without any objections, so ordered. We will recess until 2 this afternoon. Legislature is back in session. The chair recognizes the majority leader.
Thank you very much, Madam Speaker. Madam Speaker, notwithstanding the House rules, I move that we revert back to motions.
Without any objections, so ordered.
Thank you, Madam Speaker. My first motion is to take Bill 201 out of the voting file and move it to the second reading file. And I have the concurrence of Senator Tony Ada, because there's some amendment that we have to try to make together. And so that's my
Hearing
first
no
motion.
objection, so ordered.
So my next motion is to place Bill 342 on the second reading file, and all of these bills will just follow wherever we left off. It's Bill 342, introduced by Mana Silva Tyrone, an act to amend 58104, Chapter 58, Title 12, GCA relative to inclusion of green technology as an acceptable activity for eligibility of a qualifying certificate application.
On that motion, without any objection, so ordered.
The next bill, Bill 389-31, introduced by the same Senator, Mana Silva Tyrone, and this is as substituted by the Committee on Public Safety, Law Enforcement, and Judiciary, an act to add a new Chapter 17 to Title 4 of GCA relative to mandatory drug testing for prospective and current Governor of Guam employees. And so this bill has, there's a committee report that's been filed.
On that motion, without any objections, so ordered.
And Madam Speaker, the next
Yes.
3 bills to which there's been a committee report, and they're all introduced by Vice Speaker Cruz. And its first bill is Bill 331-31, and it's an act to rezone lot number 10060 REM 1R2 in the municipality of Dedido from agriculture to commercial C zone, and which was, and so that's my first bill.
On
My
that
first motion is to place Bill 331-31.
331,
Yeah.
hearing no objections, so ordered.
And the same, they're all in the same area, and so the next motion is to place Bill 332-31, also a rezoning measure.
The number again?
332-31.
332. On that motion, without any objections, so ordered.
And the next bill is 333-31.
333.
These are-
333.
Yeah, and
that's
these
also
are
by-
all as introduced or substituted versions of these 3 bills, and the substituted version is in the committee report.
And these are all rezoning. Is that correct? All
Yes.
these 3?
No, I think they're
I
all,
didn't-
yeah.
I didn't hear
As
the,
introduced, 331 is the next bill.
So 331, 332, and 333.
331, 332, and 333.
And those are all
Yeah.
rezoning bills. So on that motion, then without any objections, so ordered.
Madam Speaker, my next motion is to, regarding Bill 448, to which you introduced, there's a request that the public hearing be waived simply because this subject matter was entertained in a previous bill, Bill 437, and so since Bill 437 is on the agenda, it makes sense that we might want to take a look at Bill 448 as well. And so a request for a public hearing waiver has been requested and granted, and so having this being eligible to place on the agenda, I move that Bill 448 also be placed in the second reading file.
Thank you very much, Mr. Majority Leader. Inasmuch as that bill was introduced by the Speaker, I will, as presiding officer, approve that waiver. Any other motions, Mr. Majority Leader?
Mr. Speaker, now that you've granted the waiver of that public hearing, I then move that since this bill is eligible for placement on the second reading file, I move that that be done.
Any objection?
Thank you, Mr. Speaker. I have no further motions at this time, and so I move that, notwithstanding the House rules, we proceed back to the second reading file.
Thank
and
you
you
very much.
determine where we left off.
Okay. Let's go back to 201. Yeah.
Thank you, Mr. Speaker. Mr. Speaker, Bill 20131 is just, I just wanted to make a slight amendment, and it's just to delete the word on page 2, line 7, starting from the word or, to line 8, ending at the word programs, to delete or comprehensive guidance and counseling values clarification programs.
Any objection to the amendment, or anybody wish to be heard on the amendment?
Mr. Speaker, is that, and that's also to delete it anywhere else that's within the bill, which
All
is
right.
also on line 20, page 2, line 20. The same, page 3, line 12, and line 16.
Okay. Did the clerk get all those? Anybody wish to speak on those amendments? It's all the deletion of one sentence. Any objection? On the motion to send the bill back to voting file? No objection, so ordered. Senator Tyron, are you ready with yours? Let's start with 342.
Thank you, Mr. Speaker, and thank you to the majority leader for placing this on the agenda. I do appreciate it. This bill I see is very timely and very important. If I could ask Mr. Speaker if we could just move Bill 342 onto the third reading file for purposes of discussion.
Any objection? Seeing none.
Mr. Speaker, what this bill does is it expands the qualifying certificate program to include businesses that we would consider green businesses. As we all know, the qualifying certificate program has been a good program in bringing businesses to Guam, and the intention of the qualifying certificate program is to expand jobs on Guam, and I do believe that what this bill will do is definitely expand jobs and provide for opportunities for people to engage in businesses and business that deal with such things as energy efficiency, renewable energy, and environmental cleanup. QCs are currently offered to companies that are engaged in various types of activities, including agriculture, manufacturing, insurance, and export trade and tourism. Currently is a strong push to go green in all facets of our lives, and now it's a great time that we do what we can to protect our natural resources on Guam. Bill 342 will expand the eligibility of qualifying certificate application to include industries, again, and activities that promote the protection of Guam's environment. It will contribute to the environmental awareness that is gravely lacking throughout our community, and while at the same time it explores green technology and businesses. I must mention that representatives of the Guam Economic Development Authority helped in drafting this bill, and it continues to receive the support from the Guam Economic Development Authority. Mr. Speaker, expanding our economy is something that we as a legislature have been pushing and will continue to push, especially in these dire financial times. I see this bill as an opportunity to bring in additional revenues into Guam and entice environmental businesses to come here and base themselves here and provide jobs for our local people. We have already received some discussion and had some discussion with folks who are interested in participating in this qualifying certificate program. So I do ask this body to really look at this and consider this a great opportunity for our island. So thank you, Mr. Speaker, and I just ask my colleagues to support this. Thank you.
Thank you very much, Senator Silva Tyron. Senator Dueñas, any other senators wish to be heard on the bill? After Senator Dueñas, Senator Dueñas, you're recognized.
Thank you, Mr. Speaker, and good afternoon. Mr. Speaker, I rise in full support of Bill 342-31. Mr. Speaker, about a week ago, maybe a week ago today, I had a really nice visit from two gentlemen that came to my office to present opportunities for Guam with regard to renewable energy opportunities. What was, I guess, most delightful in the conversation were these two guys were graduates from our local high schools, went off and both had very productive military careers, retired, and were comfortable in the States, but decided that their yearning to come back home just drove them to do so, to participate in our economy, knowing that there is an impending force realignment, and just to come back to Guam and contribute. It was amazing, their stories. One of them, I guess, one of the reasons why I really took to listening to his story prior to the presentation of the proposals that this company is working on, was the fact that he was a graduate of VOTEC. And he was so proud. And so we got into workforce development discussions and all kinds of different areas other than what they were there for. During that conversation, Mr. Speaker, we had a conference call with an individual in Hawaii that is giving technical advice to these two gentlemen. Mr. Speaker, these two gentlemen have already done over $7 million in business on Guam in the renewable industry. And they're looking to do so much more. During our conversation, Mr. Speaker, they presented a chart showing all of the 50 states and territories, indicating the tax incentives given to companies to engage in this renewable effort in terms of on the mainland U.S. and Hawaii. And sadly, Guam was empty in all categories. So I commend my good colleague for moving this forward. And there are other pieces of legislation that have been introduced in Hawaii and the other states that they have forwarded to my office and other offices for review. So this is a start of something great, Mr. Speaker. I know for many years we heard, not only because of the forced realignment, but we have heard the cries of many of those who have run for office, either in the for the governorship or for the legislature, that we want to bring our people home, wherever and whenever possible. And here's a story of it really happening, and not just coming home to have a job for themselves, but to create an industry and to provide jobs for our people. So it's appropriate, very appropriate, Mr. Speaker, that we start here. And I hope that this will be the beginning of not only this company, but many other companies' opportunities to avail themselves of opportunities for Guam and for our people. One last thing before closing, Mr. Speaker, that I was really touched by is that they explained that their model and even their Hawaii counterpart would only come out to set up and establish the parameters of the company, but would leave as soon as everything was underway because they believe in local employment and growing local employment. I know that you in particular, Mr. Speaker, have pounded that point home, sometimes to the dismay of some of our good executive branch partners. But the fact of the matter is that is their commitment, and they've already done the first $7 million worth of business, and this can only help them facilitate moving forward more. So, Mr. Speaker, I'm proud and happy to support this legislation, and thank you for the opportunity to speak on it.
Thank you very much, Senator Duenas. Senator Mbini, then Speaker Wampat. I realize you, but I have to go by order.
Thank you, Mr. Speaker. I commend the author of this bill primarily because of my passion toward green technology. But there are other residual benefits that may not have been mentioned. One of them, of course, was mentioned previously by the previous speaker about the importance of jobs that can be developed from this. And I thought I'd share with my colleagues here and now that one of the concerns that potential investors or business people who wanted to start this kind of industry in Guam, one of their biggest concerns was, well, if we were to start this, how are we going to fill the positions? There aren't enough people who are skilled. And so, this opens up opportunities for new trades, new skilled positions. And these are good paying positions. But also, I think for the rest of us, or the consumers of this kind of green technology, this is where I feel I'm excited. I'm hoping that by bringing in these kind of industries, giving them opportunities where they can afford to bring this industry to Guam, will make the kind of energy efficiency products more affordable for the rest of us. As you know, as much as I'd love to put a solar panel in my home, it's not very cost effective, but by inviting new industry to come in onto Guam and to give them these kind of opportunities and incentives, that the residual effect would not only be for those who can get jobs, but for those of us who will be the consumers of their goods. So I commend the author, and I'm sure that businesses that have come to Guam in the last year or so who have been interested in doing this, and that means also our returning residents, will be very pleased that this is something that they can afford to take advantage of. So again, thank you. I'm in full support of Bill 342. Thank you, Mr. Speaker.
Thank you very much. Madam Speaker, you're recognized. Any other senators wish to be heard? Senator Rodriguez and then Senator Adler.
Thank you very much, Mr. Speaker. Mr. Speaker, this technology, green technology, is already mandated, yes, by federal law. And I know, of course, now what this does is that it's the issuance, of course, of these qualifying certificates. And I know many, about 3 or 4 legislatures ago, there's been the concern of the body then and continue to be, of course, is that when we give out or expand qualifying certificates, what we're doing then, and we're hearing this complaint, we're hearing it in the radio, we saw it in the newspaper today as well about revisiting, and we've said it all the time, but we've never really done it. And we've asked Gita, as a matter of fact, to even look at it to see whether some of these QCs actually ought to expire, and where then do they need to cut back, because some of these establishments are well established already and have sold and gone through different hands, and they still qualify for these certificates. I'm not saying, of course, that's new ones that would help generate, additional revenues, that we should not consider them, because the whole idea is to be able to do this. But green technology is the buzzword of today, and everyone is doing it. Our government is doing it. We have UOG and GCC already participating in this. We've got GPA as well looking at this, and actually ready to set up some of these, pilot green technology. So my question is that, we have these institutions, unfortunately, yes, they're government institutions, and they get nothing. They get nothing in return. And always the concern is that, yes, we may bring these companies that are going to come in here. We can easily say, yes, they're going to establish here and then take off and leave. I kind of course, question that. It's just like when I went and rezoned my property to commercial, and I went through the normal process, by the way. But then, of course, the idea was, and this is what I was told, once you rezone it to whatever it is, then basically you can do whatever you want. If it's commercial, it doesn't mean I have to limit certain type of business activities that they may not, want. Of course, I would like wholesome activities. But once it's done, you're given that, they can do whatever they want with it. Now we have this other program, EB5, where, of course, we want to bring investors in, foreign investors, but those have qualifying reasons, regulations to be able to establish themselves by making sure that they do invest in Guam by investing like $500,000. In addition, they must also save or create about 10 jobs on the island, for them to even be considered to be given that benefit to be able to come in, to the island. So I just, every time I think about what we do, of course, we need to be really cautious. Of course, is how much are we giving away, and especially now in light of this $43 million threat of a cut, that may or may not happen. But the reality is, we know is that has been the mantra of this administration, by saying then we need to go in and we need to cut. And I know that he made a statement some time ago, and maybe he might have forgotten it then, but that he said he wasn't going to sign any bills, of course, that's going to take money away or increase the spending of the government and increase the operations of the government. So that's all I have to say. Thank you very much, Mr. Speaker.
Thank you, Madam Speaker. Senator Rodriguez and then Senator Tometa.
Thank you, Mr. Speaker. Mr. Speaker, I like to commend as well the author for her efforts in looking at ways to diversify ourselves, especially with green technology. This is something that I have been very passionate about, and something that I really think that we need to move our island into accomplishing, so that we can save some money in terms of our new buildings and in terms of what we what we pay for utilities. But Mr. Speaker, I too share the sentiments of the previous speaker, in that when we do these kind of initiatives where we're adding a new industry to be able to take advantage of this qualifying certificate program, a program that Mr. Speaker was really meant to bring in industries that are not really, I'm trying to find the word for it, but to bring in industries that are very difficult to establish, but we see the potential. Green technology, Mr. Speaker, is something that is happening today. It's something that people want to do. Not only is it good in protecting our environment, but it's also it's a matter of it's economics. It's something that people know if they incorporate these types of technologies in their buildings, in their homes or offices or at schools, there's a return. And that return would be in lower power costs, in savings in water. And so, Mr. Speaker, the qualifying certificate, and Madam Speaker, I want to tell you that's something that I myself am really looking into because it's something that doesn't work for us today. Take, for example, the health insurance industry. In 2010 alone, Mr. Speaker, about 18 to 22 million is what our people, this government, has lost in revenue because of the qualifying certificate in just that one industry. So when we talk about the need now to find this enormous amount of $43 million to cut, we need to look at areas such as the qualifying certificate. And so if we're going to go down that path, go down that road, I don't think it's something we should right now be adding into promoting such as something with green technology when we know that this is what people want to do now. There are a lot of other incentives that would bring these investors to Guam. Guam being American, U.S. soil is something that Asian investors have looked at, Asian companies have looked at and said, because of our, because we are U.S., U.S. territory, U.S. soil, there's ways. Take, for example, the LED lighting. People have looked at the possibility of bringing these different elements that make an LED lighting, bringing it to Guam, of course, and assembling it here. And of course, there's other requirements that would require the use of made in USA, but looking at that because of our location, because of our status, and being able to develop that industry here, exporting it out to other areas of the continental United States. Take, for example, the U.S. military, where they must purchase made in USA products. And so the idea of green technology is something that we need to pursue. It's commendable. However, adding another industry into the qualifying certificate program at a time as what we're facing today, I think is just not the right way to go. So with that, Mr. Speaker, I don't support this measure. Thank you.
Thank you very much, Senator Rodriguez. Senator Tom Matta, you're recognized. Any other senators after Senator Tom Matta? You're recognized.
Mr. Speaker, I rise in support of the bill, but with some reservations. And the reservations that I have in particular is that, first of all, let's just, let's clarify. What are the benefits of a qualifying certificate? A qualifying certificate, according to the Guam Code annotated, 12 GCA Chapter 58, Section 58-101, a qualifying certificate is a contract valid for a given period of time, executed by the governor upon recommendation of the Guam Economic Development Authority between the government of Guam and the beneficiary, which has qualified for certain tax rebates. Okay, that defines that. But the benefits of a qualifying certificate shall entitle the beneficiary to tax rebates or tax abatements or both in return for meeting the conditions and requirements prescribed by the authority in this chapter and in the qualifying certificate. And so basically what this means is that granted, one of the incentives for new investments to come in is to reduce that cost to them by basically assuring them of tax rebate benefits. The concern that I have is that we are now up to 15 eligible categories, and now we are adding the 16th. And but I feel like, it's like all these are important, all these 16 categories. And I don't really agree that that is the case. Now, maybe 20, 30 years ago, certainly tourism and services was very important and probably should be at the top of the list, such that then the following activities in the order of priority shall be eligible for consideration for tax rebates. So what that means then, if we kind of put some sort of priority to these categories, then basically if you've got three applications that come in for qualifying certificates, one for this renewable, the green technology, followed by another application for qualifying certificate to build another hotel, and a qualifying certificate, for example, insurance issuance. Now, I would imagine that there's some limits as to really how much tax rebates we would want to put out. Granted, these business activities are theoretically going to create jobs for the local people, and those are all the benefits. But we found that that's not always the case, for example, especially in the hotel industry. Sure, granted, the car valet, the custodians, the people who make up the rooms are all locals. But up in your management levels, most of those are really actually imported from the mother corporation. So it seems that it would be appropriate if we were to put in, for example, I mean, if it is really green technology that we want to incentivize to come in and set up here on Guam, because by doing so, then it forgoes the need to burn up fossil fuel that we have to export from Singapore, and that's money that just goes out of the island, and otherwise money that could otherwise be circulating here, and of course it contributes to cleaner environment. And so if that being the case, I certainly would put, for example, items 15 and 16 up there at the top of the category. I'll put number 16 as number 1 on the list, number 15 as number 2 on the list, and renumber everything. Certainly agriculture falls real close behind that, aquaculture, mariculture, manufacturing, commercial fishing, services and tourism. I mean, those things go, but I think the top 5 that we should be looking at are things which really provide an alternative to having to burn fossil fuel. So in that case, I would like to offer an amendment on line 16 that the eligibility for a qualifying certificate shall only be issued to the following entities: any trust, partnership, sole proprietorship, limited liability partnership, limited liability company, corporation formed under the laws of Guam, or possessions corporation, as defined in section 58-106 of this chapter, engaged or about to engage in any of the following activities, comma, in the following order of priority. So in essence, we're saying not all 16 are equal, of equal importance. If we're really wanting to go green and stop being dependent on fossil fuel, then I think we should give some priority to green technology. And so along with that amendment is actually then, so on line 16, it would read at the end, it says the following activities, comma, in the order of priority, and then I would take item 16 and place it as number 1, item 15 as item number 2, and then renumber everything else. That, Mr. Speaker, is my amendment. And if we really are wanting to go green, then I think we should really acknowledge the fact that they are not of all equal importance. We're not saying that the other categories are not going to be considered. We're just saying that when 3 applications come in, you put the other 2 aside and you look at the one first for green technology. If it does not merit consideration, fine, put it aside, and move on. Thank you, Mr. Speaker.
On the ADA amendment, I see the hand of Senator Yamashita. Anybody else wish to speak on the ADA amendment? Senator Yamashita, you recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I think the points made by the previous speaker are points that I think at least two other senators have raised, and that is what does the QC program do for our island, and how is it going about doing that? The mover of this particular Bill 342-31, I believe, simply wanted to include green technology as an item that could receive benefits of a qualifying certificate. I may be wrong, but I don't believe the intention was to say that green technology was at the top of the list and is the most important. I would suggest that if we were going to prioritize the industries, that we are going to prioritize the economic engines of our island, and that needs to be done by a group perhaps represented by our industries and perhaps provided guidance through GETA now, thank you. I see the qualifying certificate program, Mr. Speaker, as an economic engine to provide incentive for businesses who want to try to invigorate and to spur the economy of our island. And so I actually object to the idea of saying that green technology is at the top and that a prioritization system will be determined by Bill 342-31. Thank you, Mr. Speaker.
Thank you very much, Senator Yamashita. Any other senators wish to be heard? Senator Yamashita has objected to the ADA amendment. Any other senators wish to be heard on the ADA amendment? There is an objection to the ADA amendment. All those in, does anybody else wish to speak? Do you wish to close, Senator Ada? All right. On the ADA amendment, those in favor of the ADA amendment on page 2, putting in the reprioritizing 15 and 16 to 1 and 2. Those in favor? Amendment passes. Any other senator wish to, if you're looking for the 8, that was me. On the main motion, Senator Tony Ada.
Thank you, Mr. Chair. Mr. Chair, Mr. Speaker, I stand in full support of Bill 342-31, and I believe that at this point in time that anything that we can do to help support our economy and have these type of technologies brought into Guam, and these are not endeavors that are easily brought here, that is not associated with extreme cost. And I believe that if we offer some type of incentive for someone to introduce or even to bring in a higher type of technology that will enhance our renewable resources, is always a win-win situation for the people of Guam and for our island and our environment. So I stand in full support of this bill. And I would just like to make one amendment, which will be on page 4, line 11 after cleanup. And this is just for the purpose of this section, just to define renewable energy. And it'll be for the purpose of this section, renewable energy is energy which comes from natural resources, such as sunlight, wind, rain, tides, and geothermal heat, and from other form of electrical power generation, which are renewable, naturally replenished. And that will fall under line 11 after cleanup.
Does everybody fully understand the amendment offered by the good senator from Sinahan?
If I can just get a 1 minute, and I'll have it passed out.
All right, thank you. A 1 minute recess. Yeah, amendment by Senator Tony Etta has been distributed. Does everybody understand that these 4 lines will go at the end of the following the last word on line 11? Is that correct, Senator Etta?
Yes, Mr. Speaker.
On the Tony Etta amendment, any senators wish to be heard on Senator Tony Etta's amendment? Seeing no hands, is there an objection to the amendment? Seeing or hearing no objection, the amendment is carried. Any other senator wish to be heard on the main motion, the bill itself? I see no hands up. I'll invite the sponsor to close.
Thank you, Mr. Speaker. You know, and I do appreciate the discussions either for or against the bill. It's always healthy discussion, and it also increases the awareness of this qualifying certificate program. I'm excited, though, to know that there are businesses that are wanting to invest in Guam and see the potential here. Mr. Speaker, with the uncertainty and fragile nature of our island economy, we need to push for the expansion of our economic activity in any way that we possibly can. And while the tax breaks are being made available as a result of the qualifying certificate program, I'm hopeful that Bill 342 will attract these off-island investors who are viable companies, who are established and who who have the know-how and the resources and the capability to establish themselves here on Guam and really help the island thrive in this industry. They use green technology as part of their operations, and I think that this bill will really convince them to bring their business to Guam. I do hope that the breaks will help entice these local businesses and to follow suit and push for the implementation of similar measures within their operations. Perhaps from the discussion, I do have to acknowledge that perhaps we do have to look at revisiting the qualifying certificate program in certain areas that maybe need to be reconsidered. But this one with the green technology is very timely, and it will entice businesses to come here. And just to answer the question that was raised earlier, these businesses can't just get up and go once they come here. There are very strict guidelines and stipulations that require them to stay for a period of time and give back to the community. And one big way that they do give back is through providing jobs to our people. And in turn, that results in increased income taxes, and it results in people spending more money in our local stores. So I thank the body for their consideration. And I did have a request from Senator Sam Mabini to be a co-sponsor, so I do ask that we also include her. And Senator Tom Atta as their co-sponsor, and Senator Chris Duenas and Senator Tony Atta as co-sponsors. Thank you so much.
On the amendment of the additional co-sponsors, on the motion to place the bill in the voting file, any objection? Hearing. Senator Tyron, you're recognized on Bill 389.
Thank you again, Mr. Speaker. 389, if I could move it to the third reading file for purposes of discussion.
On the motion to substitute the Bill 389 as substituted and to place it in the third reading file, any objection? Hearing none, so ordered.
Mr. Speaker, this bill is fairly simple. It establishes minimum drug testing requirements for government of Guam employees and applicants. Guam law currently doesn't contain an all-encompassing uniform drug-free workplace policy for the government, and the Department of Administration, they do have a drug-free workplace policy, which is according to an executive order, but nothing is established in statute. So what this bill does is it would establish and solidify it in our Guam code. The judiciary, I will point out, has its own policy, but for some odd reason, our legislative body does not have a drug-free workplace policy that it currently follows, although we are a drug-free workplace, that we do say we are a drug-free workplace, but it's nothing according to statute. Now, if enacted into law, Bill 389 will strengthen the government's current drug-free workplace policy, and again, by solidifying it in the Guam Code. And while it does set minimum requirements, it doesn't prohibit any government entity from establishing a drug-free workplace policy for itself. When we put this bill together, we did work in very close collaboration with the Department of Administration, who did say that they find it necessary to put this in the code. And really, I see this as, you know, we are public servants. We are working for the people, and we are working on their dime. So we should be held at a higher standard, and as government workers, we should not be allowed to use illegal drugs. So I thank the body for considering this bill, and I look forward to the discussion. Thank you, Mr. Speaker.
Thank you, Senator Tahirun. Senator Palacios, you're recognized. Anybody else besides Senator Palacios after him who wishes to speak on the main bill?
Thank you, Mr.
Senator
Speaker.
Palacios, you're recognized to speak.
Mr. Speaker, I rise in support of Bill 389-31, of course, as substituted by the committee. Mr. Speaker, I believe the $15 investment in making sure that we have a clean and honest workforce, I think is worth it. Many times, government of Guam employees are arrested for illegal use of drugs. Not only that they jeopardize the life of their co-workers next to them when they're under the influence, but the embarrassment brought upon this government as employees of this government is just tremendous. And so it would not be a burden, considering, of course, that the investment to clean out and maintain a decent workforce, an honest workforce, is worth it. It also manifests a good image on the part of the government of Guam as an employer of good, honest, and clean employees. Mr. Speaker, Section 17108 on page 9 is already existing. And I just want to make sure that this is not a new section. And we're at 108, and this is the zero tolerance for law enforcement and designated positions under the safe harbor provision. And so if this section is the same section, then it's just a repetition here. Otherwise, if it's a different section, it's a duplicate. So I just want to make sure that there's no complication there. There's no technical complication. But it is already existing under, I think, 3 months ago. It was a bill that I introduced to do a zero tolerance on those positions, which is essentially what Section 17108 on page 9 intends to do. And again, Mr. Speaker, I rise in support, and I request the author to make me second co-sponsor of this bill. Thank you, Mr. Speaker.
Thank you, Senator Palacios. And it will just take a 1-minute recess, and we'll clear with legal counsel to make sure that this is not considered an amendment by later promulgation. I've cleared with legal counsel that 17108, or if it's going to be renumbered so that it does not affect your provision in previous law, all right? Because we want that very clear, that there was no intent by this provision being included in here to amend your previous statute. Any other senator wish to be heard on the bill? Any other senator wish to be heard on the bill? Hearing none, I'll invite the sponsor to close.
Well, thank you to the body for considering this, and I would just like to ask that we place Senator, the good chairman of the Public Safety Committee, as second co-sponsor, and then move the bill to the to the voting file. Thank you.
On the motion to place Bill 389 in the voting file, is there any objection? Hearing no objection, it'll be moved to the voting file. We'll take a short minute recess.
Vice Speaker Cruz, I'll recognize you on Bill 331.
Thank you very much, Madam Speaker. Madam Speaker, Bill 331 is
Can we move the bill, sir?
yes. Can I move Bill 331 to the voting file, and I'd ask for an opportunity to speak? I mean,
Please
to the
proceed.
third reading file, and I ask an opportunity to speak.
Please proceed.
Thank you very much, Madam Speaker. Bill 331.
Mr. Vice Speaker, please, one moment, please. I understand. Does everybody have a copy of Bill 331? Okay, I'm going to take a 30-second recess to make sure that everybody gets a copy. I understand the clerks don't have one. Speaker, I do apologize. Please go ahead and proceed.
Thank you very much, Madam Speaker. I apologize for the delay. I thought that it was distributed. You will find on your desk three successive bills, 331, 332, and 333. These are three adjoining lots owned by one owner, but under our standing rules, each lot had to have a completely separate bill number because we can only do one per bill. This property, as you can see from the map that's enclosed in the committee reports, is along Route 3 across from the McDonald's entering Nicktams. That whole area has been zoned commercial on the other side. There's even an M1 a little further down. And just in compliance with the law that was passed by Senator Duenas, though this bill had originally come back out for on the floor, because Senator Duenas' bill had become public law, it had to go back to Department of Land Management for its either approval or some kind of word on its support for it. So I have a letter from the chairman of Committee on Appropriations, Taxation, Public Debt, Banking, Retirement, and Land. It's dated February 29th, where he lists a series of properties. We're asking the Director of Land Management what his position is relative to the rezoning of this property from A, agricultural, to C. And I'm not sure if you want me to read entire, maybe I should read it into the record. The letter from the Director of Land Management dated July 6, 2011 says that over the years, Route 3 has undertaken a dramatic transformation in its physical aspects. It has been realigned and widened to what is now traffic has exponentially increased and vehicle speed has correspondingly increased. In addition, the lots that are in question here parallel Route 3, development within the area encumbered by the AV gas and strictly parking. And then as it relates to whether or not this would be a good idea to rezone it. As it relates to public necessity, the Director of Land Management writes, a positive aspect of rezoning the property to C is that it has the intent, that it has the potential to bring benefits and services to everyone nearby or the traveling public at large. A new commercial establishment with additional and new commodities for sale can only provide greater convenience for everyone. The surrounding residents will be provided additional retail and other professional commercial services that are mostly found in nearby municipalities. Although a new commercial activity may be considered as being competitive with now existing commercial activities, this competitiveness, however, should be viewed as a positive manner such that it can initiate the introduction of a variety of new products not offered in other commercial establishments. Thus, a diversity of service and products can be brought by a new commercial establishment which will benefit the immediate neighborhood as well as the general public, and in essence, is a convenience to everyone when such products and services are readily available. As it relates to general welfare, the proposed rezoning of these lots would be compatible with current land use. Within a distance of 900 feet, there also exists several commercial activities in operation, such as a mini commercial plaza with small store and laundromat and a gas station with a convenience store. Also on the same lot as 7-1 is Shell gas station. A commercial building exists which contains a small restaurant, a laundromat, and other small retail activities. The location of the property to be rezoned and the designation as commercial zone can only enhance and complement the other commercial activities. As in higher density and intensity zone consideration, infrastructure availability and capacity must be highly considered. We find that all the major infrastructure exists and are considered more than adequate to support the C rezoning. The subject lots to be rezoned are fronting Route 3 and one lot, Lot 10129-1, fronts only a collector road, Artero Road, which is 80 feet wide, which is, of course, a turn connects to Route 3. Water, power, sewer, telephone are all in place. The use of such infrastructure system, so anyway, it goes on. And so, as you can see from the letter from the Department of Land Management, they believe that this is a good idea. And so I ask that as it relates to lot 10060-REM-1-R2 in the municipality of Dededo, as put forth in Bill 331-31, be rezoned from agricultural A to commercial Z. And I ask for the support and consideration of my colleagues to allow this family to take advantage of the development that will be happening in that area. I thank you, Madam Speaker, for allowing me to speak on 331. And I ask my colleagues' support.
Ben Provetsu, Vice Speaker. Anyone wishing to speak on the motion? Senator Chris Dueñas, you're recognized.
Madam Speaker, thank you very much for the opportunity to rise in full support of Bill 331. I rose to speak on the bill just to say that I'm really elated on how the legislation we passed in this session works. And the public got to see a clear demonstration of that, as read into the record by the retiring speaker. The opportunity for land management to comment and to give very comprehensive overview of why this is a good thing to do, and that it's not just simply the legislature acting on a whim to do what's sometimes considered favors for others or the like. And this is why. And obviously, when it comes time to vote, all of us will have an informed decision to make. Now that we have the full complement of Department of Land Management's testimony. So I not only rise to support this bill and the subsequent bills for contiguous lots, as per our standing rules, to have to do one piece of land per bill, but I also just want to say I'm quite excited today to see that the process really works. Thank you, Madam Speaker, for the opportunity to speak on this bill.
You're very welcome, Senator Duenas. Does anyone else wish to speak on the bill, on the motion? If not, Vice Speaker Cruz, would you care to close and put into
I
the
would
vote
love to
file?
close, and in as much as he has championed this, I would hope that Senator Duenas would do me the honor of being the second co-sponsor on the bill.
On the motion, are there any objections? No objection, motion carries.
I move the bill to the voting file.
Without any objection, so moved. We'll go ahead and recognize you, Vice Speaker, on Bill 332-31.
Madam Speaker, Bill 332 is the next lot over. It's lot 1006 0-REM-R6-NEW in the municipality of Dededo from agriculture to commercial Z. Again, this
Can
bill...
we just move it first
Oh, I'm sorry.
to the third?
I move it to the third reading file, and I ask for the opportunity to speak.
Sidamasi.
All right, this is to rezone lot 10060-REM-R6-new in the municipality of Dededo from agricultural A to commercial Z. Madam Speaker, this is an adjoining lot, and the testimony from Department of Land Management is the same for this one, and I ask that for the support of my colleagues in also approving this one. It has the very same supportive testimony that I read 4331. And I can see the signal from you that you'd like to be the second co-sponsor on this.
Both bills,
And if you would, I'd like to amend the title to have you as the second co-sponsor for this one, and again, ask Senator Duenas if he'd be the third on this one.
Yes.
All right?
Without any objection? No objections, so ordered. Thank you very much. Anyone else wishing to speak on 331? If not, would you like to move it
Just
to the voting?
to move it down to the voting file. Thank you very much, Madam.
No objections? Motion carries. One more, Vice Speaker, you're recognized on Bill 333.
Thank you very much, Madam Speaker. Again, Bill 333, I'd like to move to the third reading file and ask for an opportunity to just speak very, very briefly.
Please proceed.
Thank you, Madam Speaker. This one is an act to rezone lot 10129-1 in the municipality of Dededo from agricultural to commercial. Again, the committee report has the map enclosed, the statement from the Department of Land Management that supports it, and the fact that this is in the best interest of not only the landowner but the entire community. And I'd like to amend the bill to have you as the second co-sponsor and Senator Duenas as the third.
On that motion, are there any objections? If not, no objections, motion carries. And is there anyone else wishing to speak? We'll move it to the vote.
Please.
To move to the voting file, no objections, motion carries. Ladies and gentlemen, we're going to go ahead and take a minute recess so that we can entertain the next bill. I do know that they're probably processing some documents, so we'll take a legislative recess at this time.
I want to thank everybody for their cooperation today. We've moved a number of bills through, so unless there's an objection, I will recess until 2 o'clock tomorrow afternoon. All right, there's a number of things that we have to do tomorrow morning, and then let's all meet at 2 o'clock tomorrow afternoon. Thank you.